Good evening, ma'am. This is Orville Arellano Doclayan from Section Charlie. And now I will recite the Article 12 and 13 of the RPC, Book 1. Paragraph 1 of the Article 12. An imbecile or insane person unless the latter has acted during a lucid interval with the imbecile or an insane person has committed an act which the law defines as a confinement is one of the a felony delito, the court shall order his confinement in one of the hospitals or asylums established for a person thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. Paragraph 2. A person under 9 years of age. Paragraph 3. A person over 9 years of age and under 15, unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provision of Article 80 of this code. When such minor is adjudged to be criminally irresponsible, the court, in conformably with the provision of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institute or person mentioned in Article 80. Paragraph 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Paragraph 5. Any person who acts under the compulsion of irresistible force. 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. Paragraph 7. Any person who fails to perform an act required by law when prevented by some lawful insuperable cause. Article 13. Mitigating circumstances. Paragraph 1. Those mentioned in the preceding chapter, when all the requisites are necessary to justify or to exempt from the criminal liability in these respective cases, are not attendant. Paragraph 2. That the offender is under 18 years of age or over 70 years. In the case of minor, he shall be proceeded against in accordance with the provision of Article 80. Paragraph 3. That the offender had no intention to commit so grave a wrong as not committed. Paragraph 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. Paragraph 5. That the act was committed in the immediate vindication of a grave offense to the one who committing the felony delito, his spouse, ascendants, or relatives, affinity within the same degrees. Paragraph 6. That of having acted upon an impulse so powerful as naturally to produce passion and obfuscation. Paragraph 7. That the offender had voluntarily surrendered himself to a person in authority or his agent, or that he had voluntarily confessed his guilt before the court prior to the presentation the evidence for the prosecution. Paragraph 8. That the offender is deaf and dumb, blind, or otherwise suffering from physical defect which does restrict his means of action, defense, or communication with his fellow beings. Paragraph 9. Such illness of the offender as will diminish the exercise of the willpower of the offender without however depriving him or consciousness of his act. Paragraph 10. And finally, any other circumstances of a similar nature and analogous to those above mentioned.